So, Renato, who really won in the Manhattan DA's case?
Uh, it's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Wow. So, Asha, we suddenly have all these topics to talk about. We're trying to squeeze them all into this podcast because a lot's been happening in the final days of the Biden administration.
Yes. Trump is now officially a convicted felon.
Which is really something.
Yeah,
And I
I mean,
will.
we've been saying it for a while, but I think technically speaking, until the sentencing happened, he was not a convicted felon. But now the sentencing has happened and he is a convicted felon.
Great question. A great point because we've talked a lot about that. And that's the way most people think about it. And as somebody who practices criminal law, it's like a distinction that we talk about that I don't think anyone cares about. Like if one of my clients pleads guilty, they're guilty, right? Or we lose the trial and that's it. They're a convicted felon. But actually, technically, under the law, until judgment is imposed, they're not.
And that could probably explain why, at least partly why Trump was fighting so hard to keep the sentencing from happening, because then it would never really be final. I mean, it kind of dovetails with his, his tactic of delaying everything.
Yeah, absolutely. And he almost did it here. I mean, it is now, we are recording this at January 10th. The sentencing occurred today. That's 10 days, 10 days before is set to be inaugurated as the president of the United States. I will tell you, Alvin Bragg and his team, were right up to the wire on this one.
Yeah. And I mean, just to be clear, the sentence was a big nothing burger.
That's beyond nothing burger. Yeah, I mean, that is like unconditional discharge. I mean, that is literally nothing. It makes you wonder. I mean, we talked about it on a prior podcast, like who, right? Like in some ways it's like, it feels like why do all this for that, right?
Yeah. And it sounds like Judge Merchan said that basically, he was imposing that sentence. He made a distinction between, defendant Trump and President-elect Trump, and kind of that basically he acknowledged that he's taking into account these political realities in giving that sentence. And I know that our colleague George Conway, who we had on this podcast a few weeks ago, made a great point on Blue Sky, where he said, I wish Merchan, given that he made that distinction, had elaborated on if Trump were not going to be inaugurated in 10 days, what sentence he would have given. I don't know if that would be appropriate or not. From what, I understand, anything goes in this kind of in this kind of hearing. Like, I guess he could have said whatever he wanted. It does seem like weirdly, not that I, that I'm not super sympathetic to Trump, but it seems like it would be weirdly would put some unnecessary stigma on him to sentence him to one thing, but if he weren't being inaugurated, I would have like thrown him in the clink.
That's right. I think it's not appropriate at all for the judge to do that. I mean, it's the sort of thing it's fun to talk about these sort of things in social media, but if you're a judge actually sentencing someone, you should not do. First of all, I will say, interestingly, you're right that you have a lot of leeway as a judge in terms of what you say during a sentencing hearing. And it is worth noting that sometimes judges do talk about what they might do in the alternative, if doing that would potentially save judicial resources and a potential appeal. So they might say, for example, I'm calculating the sentencing guidelines this way or that way. And if I'm wrong about this particular guideline provision, I would have sentenced X or Y. So that this way, if the Court of Appeals disagrees, they can just reduce the sentence and they don't have to send it back down and have a whole other hearing.
I was going to say, in that case, what you're saying, though, is that it would be a mitigation. In other words,
correct.
They're giving the lower alternative, whereas, what George was suggesting is that Mershon talk about how punitive he would have been otherwise. And I don't know. I mean, I would like to know. No, don't get me wrong, but I feel like that it would have. It kind of gives me vibes of Comey doing his press conference about not charging Hillary and then being like, "And she was reckless and
Right.
sloppy and whatever." That it's like, then like if you didn't charge her, just shut up.
Exactly right. It's exactly the same principle, and that's why Comey is wrong, and that's why it would have been wrong here. Like the purpose of a judge or a prosecutor is not to opine about what somebody could have done and what they could have done. Prosecutors should bring cases they could prove, and judges need to render the decisions before them. I mean, actually, really, there's a lot of judicial canons that we talk about, and one of them is you shouldn't be announcing and making decisions that aren't before you. And in that one, it comes down to actually sort of the concept behind having a judicial branch in the first place, right? They're there to decide the issues that are before them, not to opine and give opinions and thoughts about all sorts of things that are not. And so, the Donald Trump before him is the Donald Trump who's president-elect of the United States. He's not there to write what-if novels, although they're very fascinating, and maybe there'll be a great what-if story someday of what could have been, but that's not what this judge is supposed to do. One thing that I will say that I'm going to give Judge Mershon some props on, and it's going to be a slight mea culpa from the last episode. In the last episode, I think both of us were pretty critical of Mershon being with this condition. Like, why'd he even throw in there a conditional discharge? Or at least I believe. I was in the order. Like, why did he need to come out and say, I'm going to give you conditional discharge in advance? It turned out that actually became very important when this went up to the Supreme Court.
Right.
And I think it drove the Supreme Court's decision, because then if he didn't say that, this actually would have potentially been a thorny issue for the Supreme Court, because the Supreme Court might have been thinking like, okay, this is kind of weird. We're going to have a state court judge potentially sentencing the president-elect to a prison sentence, and this could really create very unprecedented federalism issues. But he basically was able to take that off the table for the court by saying, yeah, I'm going to be sentencing this guy to unconditional discharge. So I'm just doing it. This is the right ordinary course. So then this way he can appeal and do whatever he wants to do.
Yes, I'm actually on the Supreme Court's website. So Trump filed for a stay on January 8th, so 2 days ago. And the court last night denied the stay. And what it says is a very short little description. And it says, application for stay presented to Justice Sotomayor, who's the justice who oversees New York, and by her referred to the court, is denied for inter alia the following reasons. First, the alleged evidentiary violations at President-elect Trump's state court trial can be addressed in the ordinary course on appeal. That goes to an argument that he made that, basically his conviction is not valid because there were official acts that were presented in the course of the trial, specifically, I think, like conversations with Hope Hicks, et cetera. Second, the burden that sentencing will impose on the president-elect's responsibility is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge after a brief virtual hearing.
That's very important. What you're saying. Yeah. I mean, it really sounds like that potentially drove the deciding votes in that, because it's a 5-4 decision. The fact that the judge says it's going to be a virtual hearing, I'm not making you fly to New York, and I'm going to post unconditional discharge, essentially mooted out any of these issues. And the court here was doing what I was suggesting that Mershon should do as a judge, which is, hey, these theoreticals about what the judge could have done is not before us, because the judge has made it clear that this is what he's going to do.
Yeah. Even so, it is a little extraordinary that it was 5-4.
One thing I would say, I mean, it is remarkable that you did have 4 justices essentially say, for this particular defendant, let's bypass the ordinary process that you would for an appeal, and instead give him essentially a reprieve effectively forever, or for at least for the next 4+ years, because of who he is. And that, essentially I do think I'm going to be different. I'm going to have a different view than some commentators on this. So some commentators are like, these four were completely lawless. Well, it's a little complicated in that I do think if Rashawn didn't include that language, the four might have a legitimate point that, hey, there's a concern that this guy might impose a term of imprisonment. This guy may do something to say, hey, Trump's got to spend all of the next 10 days that he'd spend focusing on putting his administration together instead on whatever, working and doing community service at a local soup kitchen. This is something that, could implicate important concerns that are inherent in the structure of the Constitution. But that was all put aside by Rashawn wisely, and something I didn't see. So given that, yeah, I mean, it's really hard to see where these four were coming from.
Yeah, and they don't give a reason for, and it's curious, like what their reasoning was and on what grounds they would have granted the stay, except like you said, just that it is who he is and it's 10 days away. And I think, one thing we should remember, and I don't know, maybe this is, Mershon kind of shot himself in the foot because he granted Trump's motion back in November. This sentencing was actually supposed to happen, I think, in mid to late November, if I recall. November 26th is the date that's stuck in my head. And it was postponed. And you have to wonder if it had taken place then, he still would have been president-elect, but there would have been much more time. I don't know if the same reasoning would still apply. I mean, 10 days is really a short time.
It is. And legitimately, anyone who's going to be president of the United States presumably has a lot to do in the 10 days before inauguration. So that's what I'm saying. I do think there are legitimate concerns there. If Merjan didn't say, I'm just going to have a brief virtual hearing and give him a sentence of nothing. But I think that what we want to take from this, I think it's important, is you have four justices who essentially were going to bend over backwards to give Trump a benefit. And it really, what I think is interesting is bypass the ordinary judicial process. And if anything that the judiciary stands for is rules and process and a system of laws, and to essentially bypass all that and say, look, there's a state court that's doing something and we're going to just sort of do something that has never been done before to interfere in its operations, even though if we let it go on, not much is going to happen. There's not going to be much harm to it. It's concerning because you really think here, Asha, if you had one vote flip in the other direction, you would essentially, could this be a forecast of what could happen in the future? I mean, what if Chief Justice Roberts retires and is replaced with Aileen Cannon? Could you imagine then potentially a 5-4 majority on the court that whenever Trump asks for a stay of anything or asks the court to do anything is what ready to grant it? It's definitely shows what a thin reed we have.
Yeah, it's very problematic. As it stands now, though, I guess he can appeal the sentence, and I guess he can also appeal the immunity claim. And I presume if he does that, he'll be doing that while he's in office.
That's right. And I mean, he actually has a reasonable argument. He had much better than a typical Trump argument on the immunity evidentiary issue because the court's opinion was pretty out there. And I actually think was written in a way to try to capture some of that. So it'll be interesting to see how that pans out. But I mean, it's all at this point a kind of an academic exercise. And to me, what's interesting about it is not like what it means for Trump and like, no, whatever. He was, it being on a Zoom and getting an unconditional discharge. I don't know how much that actually matters. But I think what's interesting to me is, we've had also another guest that we've had in this podcast is Steve Vladeck, who I know we both follow and read. He talks about the shadow docket. That's really what this stay was, right? Like a one paragraph, basically just kind of throwaway remark that really, I think, forecasts what we could see from the court to come. And I mean, you can imagine, because Trump often doesn't really care about the formalities, rules, laws, Constitution of the United States. The Supreme Court having a lot of these potential 5-4 or 6-3 the other way decisions either are doing what Trump wants or not.
So on the immunity claim, though, if that were to that's something that could also go all the way up to the Supreme Court. And if they were to decide that there was evidence that should not have been admitted because they constituted official acts and that it was substantially a part of the verdict, I'm assuming they can vacate the conviction. Is that right?
Yeah, I mean, the question would just be whether he gets a new trial or whether it vacates the conviction, but I presume that they can and would. For all practical purposes, he would say that he was vindicated from that.
100%.
I really thought at the time, and we talked about this possibility earlier after the immunity decision many months ago. And I think at the time, I'm like, well, at that point, who cares, right? Because, it was played out before the election. And, ultimately, there's a lot of TV ads talking about his many felony convictions and so forth. And, it hurt Trump either way. But I do think for purposes of history, but also a talking point for Trump, if this gets tossed, and I'll make a prediction, I think he's got a very good chance on that one, because I think he's more likely than not, because if the New York courts don't do it, I wouldn't be surprised if the Supreme Court
Yeah.
does.
Yeah. And that might be Robert's play
Yeah.
in terms of denying the stay, you know?
Yeah. At the very least, yeah, he'll get the final word on that. And we know that when it came to that immunity decision, his vote was decisive there,
Yep.
because Justice Barrett had a much more reasonable approach in her separate opinion, that if he joined, that would have caused
In fact,
everything to
she
change.
disagreed on the evidentiary point. She
Yes.
categorically did not believe that even if you were to create immunity for official acts, that it should somehow preclude using official acts as evidence of another crime. So, yeah, it would be very interesting to see, or it will be very interesting to see how that turns out.
Yeah, and that's why I think this whole question that we've been talking about is so important, Asha, is, a lot of our viewers and our listeners are thinking ahead, and they're trying to think ahead to what we have in front of us, because no one knows for sure. But this is a tea leaf of sorts, is a lot of what we have grown to care about in our constitutional system in order depends a lot on the votes of Justice Barrett and Chief Justice Roberts. And in many ways, that's a thin reed for a lot of things to be resting on, but that's where we're at.
We've hit rock bottom when Chief Justice Roberts and Amy Coney Barrett are the swing voters on the court.
So Asha, that was not the only big news. We had trouble coming up with what stories to cover because there's so many of them.
Yeah.
But also, we still have not seen and may never see Jack Smith's report. After the Mueller report sold so many copies, it was all over the internet and discussed so much. Here we have actual prosecution of the former president, now president-elect of the United States. And there's been a big fight over what parts of that report are going to be released at all.
Right. So what we know about this report is that, like Mueller's report, it constitutes 2 volumes. Volume 1 is about the January 6th prosecution, and volume 2 is about the Mar-a-Lago prosecution. And the complication here is that while Jack Smith has dismissed the case, asked the court to dismiss the case against Trump once he was elected, there are 2 co-defendants, Walter Nata and Oliviera.
Carlos de Oliveira.
Carlos de Oliveira, who were named as co-defendants in that case, which DOJ intends to proceed. I mean, we presume that at some point when Trump takes office, he's going to have those cases dismissed and probably pardon both of those defendants. But right now, those are active cases. And so, one assumes that volume 2 of this report has information about them. And, that's problematic because there's an ongoing prosecution.
Yeah, that's right. And they have due process rights. I mean, we talked about this when we were talking about what would be fair to Trump, what would be fair to Hillary Clinton, and so forth that we talked about in the prior segment. Walt Nauta is a United States citizen who is facing a prosecution. He's presumed innocent, and having all of these facts that might not be admissible in a court of law thrown out there to the public, by the prosecution is obviously problematic. And it's a sort of thing that, would never happen in a typical case. Usually you have, for example, a press release coming by the Justice Department that just summarizes what's in the indictment or in the complaint, and that's it. And then says the guy's presumed innocent, and nothing should be inferred from that. It's not suggesting guilt. And then any other evidentiary points would come in a filing, or would be coming in a trial after a ruling by the judge. You wouldn't just have prosecutors say, hey, we're going to create essentially a book detailing all of your misdeeds and all the evidence and throwing it out there for massive news coverage.
Sure. I mean, I will say that none of that implicates Volume 1, as far as I can tell. I can't imagine that any of that would have any bearing on what's in Volume 1 in the January 6th case that took place in Washington, D.C. I think the importance of Volume 2, in my opinion, and I think I've said this before, is to the extent that Jack Smith lays out his theory of the case in terms of the evidence that he gathered. I think Volume 2 contains information about Trump's motive in keeping that classified information, and or details about what he might have done with that information, with those classified documents. And I think that's potentially explosive, and it may explain why Trump is desperate to not have that ever see the light of day.
I'm sure, and I'm sure there's some embarrassing details or concerning details or details that would cause you to question Trump that are in there, right? Not every detail that they determine in their investigation is going to be in the indictment itself. There's always details, evidence, witness statements, and so forth that aren't in there. So of course he wants to keep that from the public eye. And one option that would be available to the DOJ, still available to the DOJ, would be to dismiss out Nauta and De Oliveira. They could even do it without prejudice, so that technically they could bring it in the future, but dismiss them out. Then they wouldn't have standing to challenge anything, and then they wouldn't be prosecuting them at all, and so on and so forth. That would be
Sorry, go ahead.
No, that would be a really clean way to deal with this in certain respects.
Do you think that would be an appropriate way to deal with it? Because I think if he did that, especially if that were Jack Smith's play, he should have done that when he requested the case against Trump dismissed. Because at this point, and we should probably rewind and talk about the so-called procedural posture of this whole issue with the report in Florida right now. I think if he were to dismiss those cases now for the purpose of releasing the report, I think validly it would look like we just want to make sure that, I mean, and maybe people think that's an okay reason, but we just want to make sure that this gets out there and everybody sees, what's important, what Trump did. I don't know. It would seem a little bit unseemly to me. But why don't you talk a little bit about how and where how this went up to appeal, what the appellate court said, because all of this implicates, again, our favorite judge, Aileen Loose Cannon.
Sure. So if we all remember this, Judge Cannon, following really the lead or the suggestion of a separate opinion by Justice Thomas in the immunity case, threw out the indictment against all defendants, saying that the special counsel was essentially unconstitutionally appointed, basically. So this is up on appeal to the 11th Circuit Court of Appeals. Judge Cannon really doesn't even have the case at this point. She's already disposed of the case, and it's up on appeal. So what all three defendants did here is they filed motions in the Court of Appeals, the 11th Circuit, where the case is, as well as before Judge Cannon. Judge Cannon went ahead and granted an order saying you can't release either volume, the first volume of which, like you said, doesn't have anything to do with her case, and saying that if they go to the 11th Circuit and get her ruling overturned, it's still in effect for 3 days after that, essentially putting the DOJ on a pretty tight clock. And essentially what happened was at the same time, the 11th Circuit reviewed the motion before it, denied the motion. And then they noted that while we're denying our motion, you, DOJ, haven't appealed or even contested the motion in front of Cannon, presumably, by the way, because it shouldn't have been filed there in the first place. But the bottom line is the 11th Circuit correctly, I think, notes that they don't have jurisdiction to review or reverse Cannon's ruling because it's not before them. It hasn't been appealed. And so while we have potentially at least 4 votes in the Supreme Court that aren't sticklers for how things are supposed to work, the 11th Circuit Court of Appeals is, and they're essentially telling the DOJ, please appeal Cannon's order so that we can issue the same ruling that overturns her order, I guess, 3 days later, or they may say with immediate effect.
So this feels like a hot mess, as this case has been since it started. I mean, I think it's interesting, Renato, that you point out that Cannon dismissed this case based on the unconstitutional appointment of the special counsel back in July. So I guess that even if she had no jurisdiction to issue the injunction, I guess you're saying, or the 11th Circuit is saying, you still need to appeal her order. You need to officially appeal that order in order for us to decide whether that injunction is valid or not.
That's right, because they don't have jurisdiction. They're not going to repeat her mistake. In other words, she was making a decision where she didn't have jurisdiction, but the appropriate way of dealing with that is to appeal that to the Court of Appeals so the Court of Appeals can resolve that issue. But the Court of Appeals, until something gets appealed to them, they don't just they're not going around giving advisory notices about what you should be done. That's not how things work. And that's the same kind of thing you and I were talking about that Judge Merchan shouldn't have been doing in New York. Correctly did. He correctly made the decision. Yeah, I'm not going to give a bunch of, thoughts and about all sorts of things in the world. I'm only going to deal with what's right in front of me.
Yeah. One thing that is interesting, and it looks like DOJ decided not to do that, to not appeal her injunction directly, because it was an injunction that was valid for 3 days. So I assume it expires on Sunday. So they're not going to appeal it.
Yeah, it's 3 days. I believe what she said was it was 3 days after. The way it reads is essentially it's 3 days after it lasts until 3 days after an 11th Circuit decision. Yeah.
The 11th Circuit decision was yesterday.
Mm-hmm. Mm-hmm. So
but my point here is that if DOJ had appealed it, it could give the 11th Circuit, I know that this has been kind of the Hail Mary that people have been waiting for, and at this point it doesn't necessarily matter except to be a smackdown, bench slap, but that I guess theoretically that it could have been a final order on which the 11th Circuit says, okay, not only was this injunction erroneously issued, with no jurisdiction, but at this point you've just messed up way too much and you're fired.
Yeah, that was never going to happen. And realistically, given the timing here, I don't even know if the 11th Circuit is going to decide the appointments clause issue. They might not. Depending on how quickly Trump acts. Right? They haven't made a decision thus far on the appointments clause issue, which was decided back in July, and by Judge Cannon. And at this point, if they just wait a week or 2 or 3, the whole case may go away. I'm sure will, one way or the other.
Is the appointments clause issue, the special counsel constitutionality of that, is that moot at this point? Because if the only active case is against the Codefendants, Jack Smith has actually passed that case back to the U.S. Attorney's Office for the Southern District of Florida. In other words, he basically whatever, withdrew or said that he's no longer pursuing the case against Trump. He passed off the case against Nata and De Oliveira to the Southern District of Florida. So he's not involved. But are you suggesting that the appointments, the special counsel legal issue still is a live issue because he brought the charges in the first place?
Right. They're saying essentially the indictment has to be dismissed because it was brought by a person who
Had
is
no
not
authority to do it.
right. It's sort of like the fake electors. Like, hey, me, you, and a bunch of my friends go meet at the local Pizza Hut and decide that we're going to elect the president. We can't do that. And similarly, we can't go to the local Burger King and decide we're going to indict somebody through a show of hands either. And so they're essentially saying that's what this is. This is like some random guy, not somebody who was appointed. I mean, it's not right. I think it flies in the face of what most courts have said, but it's a random district court opinion, and I think the 11th Circuit may just be happy to turn the chapter on this episode.
Well, and if the 11th Circuit were to rule on it and go with all of the other courts that have actually considered this and overrule canon, presumably that could get appealed to the Supreme Court.
Right? It could.
And then there would be the opportunity for the Supreme Court to make a decision about the constitutionality of the special counsel across the board. And we already know where Clarence Thomas stands on that. But, I don't know, like if they were to strike that, if they were to say that the special counsel regulations, all of that is unconstitutional, I suppose that would also effectively, retroactively kind of invalidate or delegitimize, the Mueller investigation completely as well.
Yeah, it's interesting because it obviously doesn't delegitimize facts. Like facts are what they are, but eventually would say that even Mueller couldn't have had that's how it'll be spun, right? That's how it will be spun for sure. Of course, it would invalidate her investigation and plenty of others.
David Weiss.
Yeah, and a bunch of others, right? But nonetheless, and David Weiss, of course, being the person who was investigating Hunter Biden. But it really doesn't have anything to do with that, right? It's just whether they would have had the authority to bring charges. And in the Weiss's case, he did. And in Mueller's case, he didn't bring charges against Trump. He brought them against others. But I don't think that's how the 11th Circuit is thinking about it. The 11th Circuit is thinking about this as judges should, which is, do I have to do this? Should I really, good judges try to do as little as possible, not as much, because judges are not supposed to be out there looking for stuff to do. And just like Judge Merchan's trying to find like a narrow way out of the situation, the 11th Circuit may be looking at this and saying, okay, we don't know what's going to happen here. We're not going to rush to make a decision that we don't have to make.
Yeah. I'm glad that you point that out because it kind of highlights how rogue the Supreme Court has gone recently, because that whole principle of jurisprudence that you decide things narrowly, you don't decide things that are not right in front of you, kind of, was thrown out the window. For example, in the immunities decision where you have these justices saying, we need a rule for the ages. We're not really looking at only the facts in front of us. It's for every president that will ever come, in the history of time. So I just wanted to highlight that you're absolutely right. It's not the guiding principle for the Supreme Court right now.
It's interesting. Yeah. Because traditionally courts, there's a phrase that you're very familiar with, I'm sure as well, Asha, one case at a time, right? That courts look at one case at a time and they build the law little by little. And that is seen as a good thing in that it gives you a time to iterate, for the law to evolve, for courts to learn on how, from the experience of, we decided this narrow issue and we're starting to see the consequences of that, seeing it play out in other courts. And then you go from there. These sweeping decisions and big changes generally aren't supposed to be how courts operate.
So I guess this brings us back to the question of, are we going to see this report?
I think we're going to
by the way, I believe Merrick Garland Jack Smith has given the report to Merrick Garland. So that's what his remit is. We know the report has been written as per the special counsel regulations. He has given it to the Attorney General. it's up to the attorney general to make it public. Garland has apparently said that he's not going to violate Cannon's, like random
Mhm.
order that she has no jurisdiction to issue, that he's going to honor it. So, we know he's not going to release anything before Monday, I guess. But he has transmitted it, from what I understand, to the chair and ranking members of the judiciary committees, as per the regulations.
And I believe that the plan is to do that even for the volume that is never going to be released, which is volume 2 relating to Mar-a-Lago, which means that we may see details because they may get leaked. I don't know one way or the other. It'll be interesting to see sort of what happens there. But I do think we have the special counsel regulations in place. They're there in part to ensure that elected other separate branches of government that are elected are able to sort of perform an oversight function and ensure that the executive is properly policing actions of other executive branch employees and others who are closely tied to them. I mean, that seems appropriate to me.
Yeah, and I think it's important to remember that particular provision, that which I believe requires the attorney general to give the report to the congressional committees, is precisely to ensure that there is sunlight on what happened. Because these special counsel regulations were kind of crafted with Watergate in mind, and with this idea that there will be a temptation, for, if it remains within the Department of Justice, for perhaps an attorney general, for example, the next administration, to just bury it, which I think it is probably what would happen if it didn't get transmitted to another branch.
Right. The goal being to capture Watergate, but ensure that we don't have another Whitewater case where it was sort of running amok. That was the idea. I think there's room for a lot of debate about what sort of regime we're supposed to have to police the president and close associates of the president. But I feel like since we have these regulations and that's what we're operating under, that's what Smith was operating under, we should follow them. So, Asha, before we go, we have talked about the cruise we're planning to take later this year. I actually had a great cruise over the holidays.
Awesome. That's right. You were saying before the break that you were going to go on a cruise. So where did you go?
So we were on Oceania Cruises, and we flew to Cartagena, Colombia.
Oh,
Yes, my wife and I spent a day there beforehand. We loved that city. We thought that was.
Cartagena's gorgeous. Yeah.
I'd never been there before, and we were in the kind of the walled city, like the
Oh, nice.
yeah, it was really
Yeah.
nice. So we had a lot of fun there, ate some great food, did a lot of shopping, got some great coffee. My wife and I are big coffee people, so we got like awesome coffee beans infused with different flavors and stuff. It was awesome. And then we went on a cruise to all these different islands. So there was it was Aruba, Curacao, St. Lucia, Puerto Rico. We got to see, it was Henry's homeland, okay,
That's
in
right.
Puerto Rico. Got to see the old town in San Juan and so forth. And then we went to the Dominican Republic and then sailed back to Miami. So it was awesome. It was an awesome trip.
That's great. What did you think of Oceania?
I loved it. We first of all, we had pretty good normal size cabin there, and it was really spacious for what it was. I mean, obviously cruise ships are not, it's not like having a massive estate, but we had a lot of space. We had a beautiful, just a beautiful cabin. We actually had a nice balcony that we were able to sort of enjoy the water together and the sounds of the sea and watching all the seabirds and so forth that my wife and I loved. But like also it was like a right size of ship. It wasn't super tiny where like there's only 50 people on board and there's nothing to do. But it also wasn't like a mega ship. And it was had a bit of an upscale feel to it. The food was really good. There were things to do, like there was a casino that would have like mini poker tournaments that I would do on sea days, but it wasn't like a mega thing. They had
Yeah.
some good stuff, some fun stuff to do.
Yeah. I've only been on mega cruises.
Yeah, this is a different experience. It
Yeah.
feels like the food is more upscale. It feels like it felt also like the staff, they would know your name. They would have a really nice level of service. They would, come to your cabin and bring you room service or turn down the bed for you. And there, it was also like if you wanted to get a different excursion or something like that, like it was, I would say, a really nice level of service.
Awesome. Well, then I am super looking forward to our cruise, which, just to remind everyone, is an 11-day cruise from July 20th to the 31st, leaving from Copenhagen and ending in Iceland. And it has stops in Norway, Sweden, and Denmark, and the UK in between there. So it looks awesome. And people are interested, they should call the travel store at 800-777-6540. So 800-777-6540. I know that it's on my website, asharangappa.com, and it
Sure.
is not on Renato's
That
website.
is true. I'm going to get my crap together. My website's just very out of date. If anyone looks at my website, you can laugh and post comments on the YouTube comments laughing about my website, which is years out of date. So I am working on it to do.
Okay. Well, if this cruise doesn't happen, I'm going to blame you.
Uh-oh. I got to get my crap together. My wife really is excited about this cruise because
I know.
it's the same ship that we were on and she loved it. And
Yeah,
so
yeah,
we've got
yeah.
to do this. We got to
Well,
make
I
it happen.
promised it for my son before he goes to college. Like, he's going to be my plus one.
Oh, that's awesome.
Yeah.
Oh wow. I can't. Well, we got to make this
There's a
happen.
lot riding on this.
Okay. I will be there. I will make this happen. I'll get it on my website, and please check out what is the number again, Asha?
800-777-6540.
All right, check it out because we definitely want to hang out with everybody and have a fun time on the cruise.